Thanks, Andy, for that awesome introduction and video. Very cool. Happy to be here. Like Andy said, my name is Laura Blunt-Ayers. I am with WR Immigration, and I am a U.S. immigration attorney. So I specialize in supporting U.S. companies develop and maintain compliant employment-based sponsorship programs for immigration. I work with my counterpart, Audrey, to support the global aspect of those programs. One thing that I think is fascinating about the benchmarking data and what we can kind of take away is just sort of the overall talent strategies from corporate America. We saw in the COVID era a huge emphasis on employee experience and attracting top talent. And now what I see from the benchmarking data is cost containment and an emphasis on retaining top talent. So we'll walk through both the green card sponsorship strategies and H-1B alternatives in the benchmarking data we have for you. But, one of the reasons I love U.S. immigration is I think it's one of the areas in law that is a net positive in that the foreign national employee is pursuing their dreams, their dream career, and their dream to live in the U.S., as well as the company is attracting top talent to pursue their product or goals within the company. And that I think it's the best for the U.S. to have these folks that are going to be contributing not only in their jobs, but in the community. So I feel really great about what I do day to day. Over to you, Audrey.
Thanks, Laura. So I'm Audrey Lustgarten. I'm the managing partner of WR's global team here, based in really hot and humid Michigan, which is quite unusual for us. Usually it's quite cold and dry. So my team focuses on helping all of our corporate clients with their needs outside the United States. So in over 100 countries around the world, we are helping those corporate clients get the permits, get the visas, get whatever they need to be able to either transfer talent, often is coming from the US. Maybe something didn't work out with the H-1B lottery, for instance. So transferring talent, but also hiring foreign talent locally in those destination countries all over the world. And trying to make it a really streamlined process because often there are multiple countries involved and it can get really complicated. So I love helping to simplify things for my clients. In terms of why the benchmarking data is so interesting, I often see my clients feeling like they're in a little bit of a silo. So they're getting, foreign national employees telling them things. They're getting managers, maybe putting some of that cost containment pressure on them. They're getting all these inputs from within their own organizations and all these pressures. And it can be hard for them to know, what do we do? What is the best policy? What are our competitors doing? What are, other companies out there doing? And I think giving them this data so that they can make informed decisions that are either in line with what others are doing or maybe sets them apart in some way from what others are doing. It's just really nice to be able to do that and to help them out in a more formal way. We've always done it informally with, oh, what are you seeing here? What do you recommend there? But to actually have the raw data from companies is just really exciting. And then what do I love about immigration? I mean, from a practical perspective, I just love knowing, helping people across different countries and cultures to connect and to get where they need to go. It's just very fulfilling to see that work out practically. And in a more philosophical note, I think I really love that once you've had that exchange, so whether someone is just coming from one country to the US or going, or going to multiple different countries, I think it honestly changes people. I think it broadens their perspective and makes them more tolerant of differences in our society. And I think that's a really good thing, particularly these days.
Totally. I think with that, we can dive right in. So I'll share my screen to dive into the materials. So like we said, we are from WR Immigration. Woolstorf Rosenthal is a lot to say, so we go by WR Immigration. And, the clients we serve for U.S. and global mobility range from AI startups to Fortune 500 financial firms. So we are capable and experts in supporting all sorts of programs in the U.S. and global space. Here's our plug to join the collective. So this is a new initiative coming from WR, and we want to invite you to join. And really, this is where we're sourcing our benchmarking data. So by becoming part of the collective, You'll have early access to the benchmarking data. You'll receive personalized benchmarking reports. You'll get invitations for collaborative community. This is meant to be community-led. In fact, WR Immigration is bringing on a community manager from a large in-house program who speaks your language and will be there to be the face of the community to make sure that the conversations are relevant to what global mobility folks are looking for. And obviously that's dynamic, so that changes over time. And she'll be really kind of the listening ear for the community to facilitate those conversations. So that's part of what you'll get by joining the community via survey data. And then, in so far as the community manager listening, it will also allow you to influence future surveys. So we hear a lot from the community about what you all need from benchmarking data to support your programs. And so becoming part of the collective will allow you to influence what you'll start seeing, what you want to see in future surveys.
Yeah, and definitely comment on there, join the collective, comment or DM us if there are topics that you are really wanting to see. I'm excited. We're going to have some global topics coming up in future benchmarking surveys, but would really love to hear your input because this is meant to be a tool for you.
Yeah, to Audrey's point, we're hearing more and more need for global benchmarking data, and obviously that can be really overwhelming. So we want to understand what you want out of that global benchmarking data to make it most relevant and impactful for your programs. A little bit about the benchmarking methodology. Again, what's going in or what's baked into the Immigration Benchmarking Collective. Well, many industry surveys are out there, right? And the majority of those are going to be conducted by third parties who cannot verify respondents in their data. So if you're coming across an immigration or global mobility survey with, 500 respondents, I think you can question the data in that often the respondents may not be from verified global mobility professionals. So it makes you question the data. And that we see that the surveys are completed in a very short amount of time, which again makes you question whether the data is relevant. Here at the collective, we're community driven and the data is going to be transparent. So we're happy to share the raw data at any point. We're going to anonymize the data. We're never going to share your responses as part of the collective. But if someone wants to see what the raw data looks like, we'll make that available for you. This is something that we feel really strongly about. And that we'll also be customizing the surveys or the benchmarking data. So if there is a way you want to see the data based on segmentation of industry or program size, we'd love to break that down for you. As well as, we're going to be sharing stories. So how are you using the data? How are our clients using the data to influence their program? This is all sort of going to be part of the community and sharing what folks are doing with the data. So not just the data, not just the transparency, but also how it's impacting programs around the world.
Yeah, and although the collective is new, benchmarking is something that we've been doing on, a smaller scale or a less formal scale for a long time. We hosted, Laura and I and another partner at WR hosted a great benchmarking roundtable in Chicago a few months ago with clients, live in person. And it was just so rewarding to see the global mobility and HR professionals being able to interact and benchmark with one another live. And that was, we were fortunate enough to be able to arrange that for a particular industry subset. So it was not just, corporate clients of a particular size, but it was a specific industry. And they found that they had a lot of overlap in terms of their global footprint. Most of them had offices in the same foreign location. So that was just really great to see that interaction and to see how helpful it was to the global mobility professionals.
Yeah, and I caught up with one individual when I was back in Chicago for AILA, the U.S. Immigration Bar, and she was remarking on how she's kept up with those contacts for informal benchmarking, because we know that the way that you all are receiving a lot of your information is from peer-to-peer resources. So we want the collective to not only serve as a way to facilitate benchmarking, but also as a way to have meaningful conversations, whether that's industry-specific, program scope-specific, or just within the global mobility space. There's a lot of really interesting conversations that you all will bring to the table with the data as the background fueling those conversations. So a little plug to take our surveys. We're going to be presenting on the green card sponsorship policies today. the information you'll be seeing is all the surveys completed through yesterday, but the survey will be open through next Thursday. So join the collective, take the Green Card Sponsorship Policy Survey, and that also the H-1B Alternative Survey is available for you to participate in as well. So with that, we'll dive right into the H-1B alternatives. So again, a little bit about our survey methodology. We fielded this survey from March 6th through March 29th this year. It took on average 6 minutes for folks to complete the survey. This is, again, a direct online survey to verified HR and global mobility professionals. Our sample size, again, we're just getting started here, was 36 respondents with an average of 12 years of experience in the industry and a program size of, on average, 270 U.S. foreign nationals. So we're hoping to grow that with the initiative of the collective. But diving right in, the H-1B Alternative Survey was really to understand, in light of low H-1B selection rates, what are companies doing? This is a question we got a lot from our clients that we've heard from around the industry. We want to understand what other programs are doing and how they're handling it. And that the most common visas sponsored in the U.S. in light of low selection H-1B cap rates are the L1, which is the intercompany transferee, whether a specialized knowledge individual or a managerial capacity position. The TN, which is set aside treaty visa for Mexican Canadian nationals. And then, of course, the F1 STEM EADs. This is the student visa that allows for 2 additional years of work authorization for students. And so that's the common, or at least the most common, visas that are sponsored in light of non-selection in the H-1B lottery. And you'll see a breakdown of what other programs support, like the O1. That is one that we're seeing in rising popularity, given the Biden administration's memo offering more flexibility for this visa classification. So we're seeing that used more and more these days than we had under previous administrations. This question, Audrey, I'm going to bring you in on this one. Is your company supportive of relocating employees overseas if they exhaust their F1 STEM OPT status after not being selected in the H-1B lottery? And that the majority of survey respondents said, yeah, their company does support relocation overseas. Of course, there's some layers here in that not every company has affiliates outside the U.S., so it's not always available to companies. But when it is, we are seeing more and more companies leverage this. And Audrey, can you comment on, the rate of support you're giving to clients in this way, and maybe timing or anything that might be relevant to sort of paint the picture on this data point?
Yeah, absolutely. Thanks, Laura. It is true. Like, this is what we are seeing in our day-to-day work as well. It is so common for me to get an email or to get a call. Some key employee hasn't been selected in the lottery. They're running out of time. The company is really motivated to keep them. What can they do? And exploring the global, the overseas relocation option. So it is absolutely something that we are seeing clients turn to day in and day out, and something that I think a lot of HRs are needing support with, because it is, you have your U.S. program. A lot of companies, have a very well-established U.S. program. They have it down to a science in terms of what are their policies, what are they going to do. But then turning to another country can be just a whole new experience for everyone involved if it's not a situation where they've had, already a long track record of sponsoring folks on overseas relocations. And that can be true even if your overseas offices commonly sponsor, local hire foreign nationals. The international transfer aspect of it can mean that, the process is different and the steps that you have to go through, and really be a great option to retain key talent if you have offices outside of the United States. Unfortunately, the U.S. has one of the most difficult and complex immigration systems in the world. So often I get comments from clients that they are really pleasantly surprised about what the process involves in another country. It's like, what do you mean I can get, if the company's already set up and established with the right sponsor license. What do you mean I can get a UK work visa in 48 hours? That's not something that, often happens in the US. It's not to say that every country out there is going to be that easy. There are certainly others that are challenging, but there are a lot of options out there. So if this is something where you're running into trouble, folks are running out of time, they're not selected in the lottery, it's definitely something that a lot of companies are considering and are using.
And then the follow-up to that question here is, so if you answered yes, so if the respondent answered yes, that they do support overseas relocation in light of H-1B non-selection, what criteria must an employee meet to receive support for the overseas relocation? And overwhelmingly, that's performance. So that makes sense in the sense that you want to be retaining that top talent, like Audrey mentioned. And that, Audrey, I'm kind of curious, like, are you seeing corporate programs with policies address performance as a basis of corporate relocation? So, how is performance defined? What are you hearing when people say, yeah, they're a top performer? How is that defined? And is
Yeah.
that a policy that you're seeing?
Yeah, I mean, I think companies have a range of approaches to that. The most common thing we see required, I think, in just our day-to-day work is kind of the manager support or the manager sign off with the understanding that the manager is not going to do that unless the person is performing their current job adequately. We do have some clients that get more formal than that have, ranking systems in terms of what is your score on various different performance metrics. But I would say definitely the most common is, the more informal measure performance via managerial support and approval for the overseas relocation. But it is incredibly, I think, important that you factor performance in when you're considering an overseas relocation, because although immigration can be much more streamlined in many other countries, the employment laws can be quite stringent. So it can actually be quite difficult to dismiss someone if you relocate them, for example, to France and that doesn't work out. So I do encourage companies to keep this in mind. And I think it's fairly natural to do so. I mean, the company is spending a lot of time and money, a lot of resources to make an overseas relocation happen. And you want to be, doing that for talent that is kind of your top talent that's really important for you to retain.
Yeah. And so this is really, again, kind of painting a picture, reemphasizing what Audrey just described, that performance is really driving the business to accommodate or offer the benefit of overseas relocation. And that another common theme is also business need, right? So the combination of, is this a top performer? Does this foreign national employee have the unique skill set or skills that are important to your business? And that, is there a business need then to retain this person? So the combination of those two seem to be what companies are saying fuels the relocation. Again, because Audrey mentioned that it takes a lot of resources to support an overseas relocation. And you want to make sure that it makes sense to use those resources. And that, I think each organization is going to define business need and top performance in different ways. But what we would recommend here is that you have some sort of criteria or definitions in the policy. So one, having a policy about whether your company does support overseas relocation, and then defining these terms, because business need and performance can be quite vague unless you buttress that with some additional definitions. And here are some quotes or some data, qualitative here of how companies are doing that.
Yeah, just to echo Laura, I think it is incredibly important to have that policy in place and to have those criteria in place so that, both domestically in the US, you can be applying that policy in a way that is fair and consistent to the various different individuals who might be in this situation of, not being selected in the lottery and running out of time. Having a policy can actually open up additional work permit or work visa options for you in other countries as well. So there are countries that allow for like the international exchange of personnel and have particular work visa or work permit types that are geared towards that and that are only available to companies that do have a policy of overseas assignments or, rotational My favorite one is in Canada. They have the reciprocity permit, and that's available to Canadian companies can sponsor foreign nationals for that permit if their, overseas affiliates are employing Canadians outside of Canada. And it actually allows you to bypass a lot of what can otherwise be painful steps in some of the other types of Canadian work permit processes. So it can drastically expedite things. It can decrease your cost. So a really tangible benefit of program in addition to just like the internal benefits. You can access additional work permit types. And I also have to pick out one of the quotes here that I think is important to highlight, the business presence in the overseas location and office space availability, considering we do sometimes see situations where it's like, okay, great, we're going to send them to Ireland or Australia or whatever it is, making sure that the company that you have, your affiliate there, has the capacity to sponsor foreign workers can also be really important. And that's something you can address when you are formulating the policy. Like, what are the menu of options that are available? And maybe some of the locations you have in office are not set up in such a way that they could host a foreign worker. So that is something that you can kind of clear up as you're going through and formulating your policy, doing a menu of options. So it's not, each time a one-off and spending a lot of time researching, well, what are the possibilities here?
Yeah, good point. So then another thing we wanted to dive into was the assessment process. Does your company, or just, excuse me, does your corporate immigration team or law firm have an established assessment process to evaluate foreign national employees for alternative U.S. visa options outside of H-1B lottery? So this was meant to understand, are your programs or programs within the U.S. doing assessments prior to registering their H-1B registrations to see if these foreign nationals qualify for other visa types like the L or the TN, to understand how they use it. And that the majority of survey respondents said their company does maintain an established assessment process to evaluate the foreign national employees for alternatives. And so this is key, that these assessments are happening before the lottery takes place. That's critical to ensuring that there is no gap in work authorization, because often the pipeline for the H-1B is, a student, the F1, OPT, STEM OPT, and that they're maxing out of their work authorization as an F1 and really relying on the H-1B selection to stay in the U.S. And so you want to make sure your program has some sort of pre-assessment process that if that foreign national employee can qualify for another visa. Now, the reality is that many of them cannot, because the options are quite limited for F1 students to find another visa classification. But to Audrey's point of, if you're going to pursue the global relocation, you want to be having those conversations early. So if you're completing the U.S. assessment and understanding that this foreign national does not qualify for an L1, TN, or the other alphabet soup of U.S. visas, if the company will support the relocation, like the majority of them do, having the conversation before March of that H-1B registration lottery year is really critical, because some countries are not going to be a quick fix to find work authorization when that foreign nationals' work authorization expires in the U.S.
Mm-hmm. And even those that are quick, thinking of the UK here, it's going to cost a lot more to have those expedition processes. So the earlier you can start, definitely the better.
And then the last question here on our H-1B alternatives was, does your corporate immigration team or law firm assess foreign national employees for national interest waiver or EB-1 green card sponsorship? We included this in the H-1B alternative survey because some foreign nationals based on country of birth can leverage a green card pathway like the NIW, the national interest waiver, or the EB-1, to go from the F1 to the green card work authorization, or EAD. This is becoming trickier and trickier these days now that EB-2 is backlogged pretty substantially. So this is something that some corporate programs are interested in or have leveraged as a strategy to avoid H-1B sponsorship. Again, it can't be used for everyone, but is something that some companies use. And so we wanted to understand what's that looking like across the board, across industry, and that 81% of survey respondents said their company does assess foreign nationals for the national interest waiver or EB-1 green card sponsorship. I would tell you that I've been practicing for 11 years, and the national interest waiver really only came into play in the last couple of years, again, in light of the Biden administration's memo on defining the administration's priorities and what qualifies in the national interest. So it's really offered a lot of flexibility that more companies are interested in the national interest waiver, where previously, because PERM processing times were not as long as they are today, companies were defaulting into PERM and not exploring NIW. So this is definitely a new emerging issue, and it's good to know that companies are overwhelmingly looking for this strategy in light of low H-1B selection rates if they can. Again, it's tricky, so you'll want to be working with your U.S. Immigration Counsel to see if this strategy works for some of your foreign nationals. Both they have to qualify under these categories, which require very specific qualifying criteria, and then they have to be born in a country that does not face long lines for green card in order to leverage this strategy effectively. Okay, now moving to the green card sponsorship. So we have been fielding this survey. And again, this data is relevant or updated as of yesterday, but we're keeping the survey open. So if you're interested in participating in the survey, Andy's dropping links to join the collective where you can participate in the green card sponsorship survey. Again, this is direct to HR global mobility professionals. The sample size here you're seeing today has 43 respondents with, on average, 11 years of experience in the global mobility industry, and that the average program size we're reporting out here is for 324 U.S. foreign nationals on average. So first reporting in is, does your company require foreign national employees to sign a repayment agreement before starting the green card sponsorship process? This is also known as like the clawback agreement. And that the majority here is that the 72% of survey respondents said their company does not require a repayment agreement. This is a question I've been getting a lot at conferences about repayment agreements. So people are really interested in it. And we wanted to understand, like, well, how many people are actually enforcing or requiring, rather, a repayment agreement before initiating the green card sponsorship? So again, 72% do not have a repayment agreement along with their green card initiation.
Yeah, and this is an issue globally as well, that we're getting more and more, not just with regard to permanent resident sponsorship, but even work permit sponsorship. There's definitely a global trend of fees just keep going up and up and up. And so that is making companies really stop, and consider that if they're going to be spending potentially, tens of thousands of dollars, looking again at the UK as an example here, their government fees are just astronomically high now, increased yet again in the spring. They want to have some assurance that the person is either going to stay with them or that they would be able to recover some of those funds that they spent. So this is something that I'm getting questions on in the global space as well. And I think stay tuned for hopefully a survey that may cover that and provide us some concrete data on the global side as well.
Yeah, that'd be really interesting. And I think the other thing to consider is that if your company is considering implementing a repayment agreement, you'll want to work both with Immigration Counsel to set the terms of that, because some things in the green card space, like the PERM not be repaid by the foreign national. So y'all want to be really clear with the language on that. So work with Immigration Counsel to ensure that it is a compliant repayment agreement. And you're also going to want to work with Employment Counsel, because state by state, there's going to be different employment rules in the U.S. about what is enforceable or what's not. So you'll have to have a lot of attorneys in the room to figure this one out, basically.
Absolutely. And it's the same thing internationally. Having that Employment Counsel there is critical, and looking at really exactly which fees you can and which are off limits is important. So you don't end up, running afoul of the rules.
And then the follow-up question is, so does your company have a repayment agreement in place to proceed or initiate the green card sponsorship? The follow-up is, for those respondents that have the repayment agreement in place to initiate green card, are they enforcing it? And the response here is that if they have a repayment agreement in place, if the company does require it, they are enforcing it. The 72% basically represents if you don't have a repayment, you're not enforcing it. And that the 23 yeses from the previous slide is that confirming respondents have a repayment, they're enforcing it. And again, if this is something you're interested in implementing a repayment agreement, make sure you have the process in place to enforce it, right? So you're going to want to be working with your general counsel team or your legal team in-house to understand who would be point on enforcing it. It might not be the global mobility manager to enforce it. The global mobility manager would be flagging that the repayment agreement applies when an employee leaves the company. And then what's the next step for the company to then pursue enforcement of the repayment? So again, you're going to want to be collaborating very closely with your employment counsel, whether that's your general counsel in-house or if that's outside counsel in the employment space, to sort of have that process in place. Another interesting question, and it's come up a lot, has your company paused the green card sponsorship this year? And 84% of survey respondents said their company has not paused green card sponsor. Interestingly, 16% of respondents said their company has paused green card sponsorship in 2024. And of that 16%, 12% cited cost cuts and layoffs as the reason for pausing the green card sponsorship. So that, is part of the conversation we're hearing in 2024 of cost containment and layoffs. So when programs are pausing their green card sponsorship, it's likely because of cost cuts and layoffs. Another small percent, 4% of those that have paused sponsorship, they've paused it for only specific roles or departments. So those were the two main reasons.
Yeah, this is actually something that doesn't apply quite as uniformly on the global side, where there are processes in place globally where layoffs would impact and put a stop. It's usually in the work permit process. So usually once you pass that milestone, the resident or the permanent residence process is a little bit more accessible globally. So that's actually a trend we're not seeing quite yet on the global side.
The other question we get and surveyed on was, does your company support multiple green card pathways? So this means, you pursue PERM, maybe based on a junior or mid-level role for that employee. And then as they become more senior or as they develop in their career, they may qualify for other pathways, or maybe they marry a U.S. citizen. Is the company supporting that additional pathway? And that 74% of survey respondents said their company does support multiple green card pathways. But within that group that does support multiple pathways, 51% of that group do so on a case-by-case basis. So this, again, if this is something your company is interested in, the reason for supporting multiple pathways may be to shorten the line for your foreign national that may be subject to lengthy green card waits based on the visa bulletin and their country of birth. So a new sponsorship pathway could level up, so to speak, their ability to secure a green card and maybe shorten the wait times for them. You'd want to look into, if it's on a case-by-case basis, again, it probably comes down to performance and how performance is defined. So that, again, is it a manager sign-off? Is it excellent on a last year's performance review, just making sure you've got that in a policy. So the case-by-case basis, to me, sounds like maybe there's not a policy addressing this when companies do support multiple pathways. And that, again, within the 74% of respondents that said their company does support multiple pathways, 14% does not cover the legal or filing fees for the second pathway. So when we see this with our clients, what happens is, we will prepare, whether that's the national interest waiver or the EB-1, and the company will sign off on the offer letter or the supporting documentation, but the foreign national employee will front the fees if it's legally permissible. So that's kind of how that works. When companies say they support, they're signing their name to it. The HR is verifying the information insofar as it meets all of the, clear, transparency of how they understand the employee to be working for their company, but then the company then isn't paying for the fees. So that's another way to think about offering support to foreign nationals in a multiple pathway, but not paying for the fees. And again, you'll want that in a policy so that's clear and consistent for your employees.
And where we run into this globally, I mean, one example is Canada with the provincial nomination programs, where employers do actually have the opportunity to support employees. It's not required under the Express Entry program, but PNP, most of those programs have an employer support aspect to it. And we do definitely see, some companies are open where they have offices in multiple locations to kind of double dipping and seeing like, oh, well, which program's a better fit, or supporting people in multiple ways to move them towards permanent residence. And again, Laura, to your point, I mean, this is often, we recommend that this be, ensconced in a policy, and the most common criteria we see for whether or not companies are willing to do this is performance and managerial support. And then in some instances also the level of seniority of the employees do play into it as well, where they're offering, a particular enhanced level of immigration support for more senior employees in key roles maybe versus those that are in more entry-level positions.
Yeah, that's a good point about seniority. I think in the US space, you're really only going to run into this question about a second pathway for sponsorship for senior employees because of meeting
Yeah, the criteria.
Yeah, criteria for the, higher level or faster pathway for a green card. It's only really going to come up for a more seasoned employee. It's not going to be available to many junior employees. So that's where you're probably going to see it anyway. But putting it in a policy would also, clarify that too. So this is by far the number one question the collective wanted to see was, is there a tenure requirement before initiating the green card process? So what are your company's tenure requirements? And the answer here is that 40% of survey respondents said that their company initiates the green card process after 12 months of employment. And so that tells me that that's like the yearly performance review, that once they've cleared that performance review, making sure the performance is in line with the company expectations before supporting this benefit with additional time, resources, hiring, that check-in after a year. 26% initiate on a case-by-case basis. I mean, I think it's surprising that 26% of companies initiate green cards for employees on a case-by-case basis, because that almost suggests to me that maybe there's not a green card sponsorship policy in place if it's on a case-by-case basis. 11% of respondents initiate after 6 months of employment, and 11% initiate immediately. This is where I wish we would have had benchmarking data, because I think we saw a lot more immediate green card sponsorship in 2020 as a recruitment tactic. I also think we weren't having the same layoff concerns, and programs were, maybe more in a batch environment, such to facilitate some of those initiation of green cards immediately. And so, I would love to have the comparison data. So again, we'll run this yearly so that we can capture these trends. But that, it's really only a small percentage of companies that are initiating the green card sponsorship immediately. So if that's a pushback you're getting from your employees about, well, this is how it used to be, or this is what it was at my other company, I got green card sponsorship immediately, know that that's a small percentage of programs that are doing that immediately. And I think it's because they want to ensure that the employee is a good fit for their company and that performance is meeting their expectations. And that's hard to do immediately, right? So there's the answer everybody was looking for.
Made you listen for a while before we gave that one.
Yeah, exactly. You're still there. Does your company consider employee performance when deciding to start the green card process? So that's the follow-up question. And that 6 survey respondents said their company does consider employee performance when deciding to start the green card process. And this percentage of respondents here, it's similar results to how companies determine whether to relocate employees outside the U.S. performance matters when supporting foreign national employees for immigration and mobility benefits. I think that's really just the conclusion here. So whether that's relocation abroad, whether that's the green card process, if the company's going to be investing time and resources into the employee, they want to make sure they're a good fit and that the performance is on par with their expectations. Okay, another question we get a lot is, does your company cover the cost of premium processing for I-140 applications? This is definitely something the foreign national employee is always pushing for, especially if they had to go through the labor market test or the PERM process, which is taking approximately 2 years these days. So they want to secure that I-140 approval under premium processing. And that 74% of survey respondents said their company does cover premium processing for I-140 applications. But I will say within that population that said they do support premium processing, only 44% said they do so if there's a clear immigration need, like an H-1B max out, which frankly, because the PERM process, that labor market test is taking so long, there are more these days that are in these sort of max out situations. So it is pushing on more companies to support premium processing because more and more cases are getting to these like max out of H-1B situations, requiring the company then to support the premium processing. 74% said they support premium processing, and within that, 12% clarified that they do so on a case-by-case basis. So whether that's, the benefit to a more senior employee or they don't have a policy and they're going on vibes, 12% do so on a case-by-case basis.
Could be an option in future surveys, vibes. That's how we make the decision. Globally, I think we see this a little bit less just because the backlogs are generally not as long in other jurisdictions. So I would say that a lower percentage support kind of premium or expedited processing on various different types of applications. But that is definitely in my wish list for a future survey so that we can deliver some more concrete data on that globally, regionally.
These are questions, again, that the members of the collective asked for. So these were influenced by our immigration collective here. And they wanted to know, does your company conduct concurrent PERM recruitment while the prevailing wage determination is pending? So this is really in the weeds. If you're in the U.S. supporting a U.S. green card program, this is a way to expedite one portion of the labor market test, and that's running the recruitment while the prevailing wage is pending. And the reason to do that is prevailing wages are taking around 6 months approximately to be issued. So if you run the recruitment in month 4 of the prevailing wage pending, you can complete the recruitment by the time the prevailing wage determination is issued, such to keep that stage at like 6 months as opposed to 6 months plus 2 or 3 months to complete the recruitment. And that 42% of survey respondents said their company conducts concurrent PERM recruitment on a case-by-case basis. So what that tells me is that some programs are doing it, but it's really probably boiling down to the sort of individual's timing. And again, because PERM is taking so long, we're seeing companies approach concurrent recruitment or these shortcuts to expedite the process for employees that may be in a situation of maxing out of their H-1B status and requiring the PERM process to be complete as soon as possible to secure the necessary milestone to be able to maintain their work authorization in the U.S. without any. This is all to say that this is not a common practice among programs we surveyed. So if you have employees pressuring you or your program to take the shortcut, you can confidently say that it's really happening on a case-by-case basis. And often your U.S. immigration attorney is going to recommend the concurrent recruitment based on the situation of the employee. So suffice to say that if you're working with competent U.S. counsel, they're going to tell you when it's necessary to meet the maintenance of work authorization goals for your employee, but that you don't necessarily have to build this into your process. Some programs will make more sense to run concurrent recruitment if you have something like batch or more uniform positions that you're sponsoring through the labor market test. Which brings me to the follow-up question, or a related question is, does your company batch PERM roll, meaning you use one job description, you reuse that prevailing wage determination, and you process multiple employees through it. This batch operation generally lends itself best to very large programs or some industry-specific programs that sponsor for very similar roles. So not many programs that we surveyed do leverage batch. So 23% of survey respondents said their company does batch perm roles, and 21% do so on a case-by-case basis. So not every program fits into the batch. It kind of depends on where are you sponsoring employees. And generally, it's STEM grads that companies are supporting the labor market test. But unless you're consistently supporting for the same position in a uniform job description, you're not going to be able to use batch. So some companies can leverage this a lot easier than others. Again, working with your U.S. immigration attorney to understand, is this something you can benefit from? It does save a lot of time and resources if you're able to leverage it. So if it's something you haven't looked at before and are curious to do, definitely reach out to your U.S. immigration attorney to find out more if this is something you've not explored previously. How has your PERM recruitment process fared in this year's job market compared to previous years? Again, we're in this cost containment area with layoffs, and layoffs definitely impact the ability of a company to test the U.S. labor market. And 42% of survey respondents said their company experienced no change in their PERM recruitment this year. 40% said they received more applicants this year. 9% said they received fewer applicants this year. Now, to be clear, the average respondent program is roughly 320 some foreign nationals in the U.S. I think I'd like to dig deeper into this one because I think industry specific, like big tech that had all the layoffs, probably is responding here that they did see more applicants because the tech positions were seeing the layoffs and maybe applying to more of these PERM recruitment efforts. So this would be a good sort of follow-up question for, a future benchmarking survey. If this is something interested, join the collective, tell us what you're interested in, because I kind of think the data would tell different stories based on industry, because I certainly have clients in the medical device manufacturing that are not receiving many applicants, where I think it would be very different for big tech that had all these layoffs, where there's qualified or potentially qualified U.S. workers that would be applying for those PERM recruitment openings. And this is the last question here of our benchmarking surveys. Has your company changed any PERM recruitment methods in response to the recent Meta and Apple DOJ settlements, Department of Justice settlements? So hopefully you know what those are. If you don't, send me a DM on LinkedIn or ask your U.S. Immigration Counsel. 56% of survey respondents said their company did not change any PERM recruitment methods in response to the DOJ settlements. Now, that might be strategic in the way that things are not changing, or it might not be an awareness. So the headline here of the Meta and Apple DOJ settlements was that the Department of Justice recommended these programs change the way they were recruiting. While these programs did comply with the PERM requirements, the DOJ had the opinion that these programs were not modeling their labor market test like they would normally recruit, meaning their programs maybe required mail-in resumes, which that is not how those companies typically receive applicants. And so that was one of the biggest changes, having to receive those electronically through their online job application portals. I've seen a reluctance of clients to want to open up the PERM recruitment on their normal jobs website. That was another recommendation from the Department of Justice. So if you haven't talked to your U.S. Immigration Counsel about this, do, because you want to be understanding what risks your PERM program is taking by not adopting some of these recommendations, and if that's intentional or if it's just a lack of awareness. So you want to make sure you're kind of digging into this a little bit more. And it seems like maybe not all programs have digested this in light of the settlements. We do a whole nother session on that, frankly.